right. Hey, everyone. Today we are going to be talking about the big case and how the DOJ pulled out of it was out of its negotiations, or it's already settlement, right? With the NAR?
It's out of a settlement conference, I call it, but settlement conversations, right?
Yeah, they pulled out, and we want to know, like, why do we care? What does that mean? So I am here with Saul Klein. Hey, Saul.
Jennifer, good to see you again.
Too. And Rachel Real of Rachel Real Real Estate in Chicago. Hey, Rachel.
Morning, guys. Hi, how are you?
Good morning. Dang. It's 1:30.
Morning, afternoon. It's still morning for Saul, right?
It
Still
is.
morning for me.
Right.
Exactly.
You were talking to me.
So,
Right.
Saul, since this is our Better Call Saul episode, can you give us a little bit of context that what's the problem? Why do we care? I know, it's a big question.
Yeah, so we'll take the small chunk first.
Okay.
And the small chunk is that the Department of Justice and NAR have been involved in a settlement conversation about what? Well, in 2018, actually, I'm going to take you back to 2008.
Okay.
The Department of Justice and the National Association of Realtors got involved in a conversation and came up with a settlement around the distribution of data from the MLS and how it could be utilized, and in particular, how it would be utilized for the purpose of virtual office websites.
Okay.
VOWs.
Okay.
Now, and so there was a settlement on how this was to be done and how it would be, and very complex. As a matter of fact, we can, and you should put up some of that information on that settlement.
Okay.
And that was a 10-year settlement. Well, over that 10 years, we really didn't hear very much from the Department of Justice and NAR because they'd reached a settlement.
Right.
So there was a settlement. So I guess that the part of that might have been they won't bother, and DOJ won't bother NAR for 10 years.
Right. That's what it sounds like. Right? Yeah.
2018 was the end of the settlement. Now, in my mind, I'm thinking, well, nobody's complaining. The settlement must have worked. People are getting what they want. I guess that's the end of it. But as soon as that settlement date came up, the end of the settlement date, the Department of Justice, the FTC, scheduled hearings and around what NAR does. And NAR doesn't own an MLS, right? It just creates rules and then provides errors and omission insurance to people that. So the Department of Justice and FTC, 2 hearings, 2018, 2019, and then the Department of Justice filed an antitrust lawsuit against the National Association of Realtors. And
right. And the big issues in the lawsuit are that the non-disclosure of the buyer agent commission, right? Which seems weird. I'd like to talk about that.
Yeah.
That I guess some MLSs can search by that commission, right?
That's an interesting piece because they actually have been a lot of research into that. And what I've heard is the numbers are small. Even for the number of people that would search for property based on commission is negligible.
Yeah.
Not even a big deal at all, right?
I wouldn't think that it would be, because most people don't, I mean, the people that I talk to, they don't even realize what the commission is. They just find the houses for their clients.
Yeah. So there's like 4 major points. Mm-hmm. And one of them is, that wasn't the buyer side commission wasn't published.
Right.
Now, remember, there have been people that have been fighting for more buyer transparency for years.
Well, I think that's like wrapped up in the thing of them saying that, like, people are saying that it's free for the buyer to use an agent.
Well, that's a whole nother piece. So in this proposed settlement, they said, well, DOJ said to NAR, maybe if you can do these things, we'll leave you alone for a while.
Okay.
So NAR came back and said, okay, we can do these things.
Yeah.
We can do this. We can do this. And then the DOJ said, never mind.
Right.
Forget about it.
Forget about it.
The Federal Trade Commission changed leadership, right?
That's another thing, the FTC, and that's a whole interesting conversation because the new leader of the Federal Trade Commission is 32-year-old lady with a background in trust busting and wrote papers on, right? So yeah, there's new emphasis now. And again, NAR has been kind of the bad painted as the bad guy for years. Matter of fact, if you read some of the and you sent me an article, right? I'd seen they always refer to it as the cartel.
Right.
Well, so when you start talking to people about they're a cartel, you know that whoever's talking about them doesn't like them.
Right. Exactly.
It's not a term of endearment, really.
Yeah, no. So the whole thing is kind of interesting. So what happened? 2008 settlement, 2018 settlement expires, 2019-20 lawsuit filed, settlement looks like everything's good. Today, or a couple days ago, DOJ backs out.
Yeah.
So what does that mean?
It doesn't seem like it doesn't seem like good news.
No, so to me, it's not. It's like the DOJ has taken off the gloves.
Yeah.
They're basically going to come after NAR for a lot more things. Now, lurking in the side are these 3 civil cases against not against MLS. It's interesting how that's put together, but 3 cases, class action suits. And the attorney, big law firms behind it, same law firms that were involved in going after the tobacco industry.
Oh.
Right. So these are, and I sent you some information on these 3 civil cases. Well, all of a sudden these 3 civil, so they come back. Not that they ever went away, but if the DOJ is spending their time in settlement conferences.
Right.
Right.
So now we need to pay attention to these 3 civil cases. And in particular, there's conversation. This is about the buyer compensation
disclosure
paragraph. No, the whole fact that the MLS is an offer of compensation. And then the fact that it is an offer of compensation.
I think that's what I didn't understand. Okay. So the
MLS is an offer of compensation.
Right.
And now what's happened is you can start wrapping this up with all these other things like, well, how much commission goes to one side? How much commission goes to the other side? Who gets to know this? Who doesn't get to know this? Why do they get to know this? And why doesn't the other party get to know this? And so what these civil cases are saying is that the paragraph in the MLS rules, remember the rules come from NAR, and that says that the MLS is an offer of compensation. And who negotiates that? The selling agent, the seller's agent,
and the broker,
the listing agent, and the seller.
Right.
They negotiate. Now, the buyer's commission is wrapped into that.
Well, it's saying, but yeah, I mean, it is, because the selling agent, once they negotiate with the seller, is saying, hey, I'll offer somebody this percent, this amount, or whatever of whatever I'm getting in order to help me.
Right. So if I have a buyer, then I'm going to get whatever commission has been negotiated or has been offered to me by the listing agent.
Right.
Now, what the buyers in the civil suit are saying is, we're the buyers. We should have the right to negotiate the commission.
Why?
Because we're the buyer. Because we're the buyers. We're the ones that
they're not paying it.
No, well, they do pay it. It comes from them.
So that's the argument is.
Don't argue.
Where does it come from?
I'm just stating the DOJ's position.
That's
right,
right, though, because
no,
that's like
think
everything.
Think about this. The buyer cannot negotiate. First of all, they don't know what it is, and that's the transparency. So the buyer doesn't know what it is. So one of the things that the DOJ said to NAR is, you got to tell the buyers, you got to put public. And NAR said, okay, we'll make that a rule that it. But
yeah, I mean, I would agree to that too, if that was just part of the settlement to be done for 10 years dealing with them.
So,
but I think if now it's open, now it's like, but to me, that doesn't make sense.
So here's the lawsuit. What the DOJ could do, what could happen here is the clause that offers compensation to the person we always call the selling agent, right? The listing agent, and the person who represents the buyer is the selling agent.
Right.
The selling agent, that commission, that offer of commission, the DOJ is saying that's anti-competitive.
Why?
That lawsuit said because the buyers can't negotiate the commission. Now, whether we agree or not, the fact is that's what they're saying. There's a clause in the MLS rules that says it's an offer of compensation, and buyers don't have an opportunity. They don't, number one, they don't know. Number two, there's no mechanism for them to say, you know what, my agent doesn't deserve a 3% commission. They deserve a 2%. Or my agent doesn't deserve a 2%. They deserve a 4%.
Right.
But there's no conversation around that because it's all wrapped up within the MLS rules where the listing agent negotiates the commission and then offers what they want. And when's the last time you saw a person representing a buyer go back to the listing agent and say, no, I need a higher percentage than that?
Right.
They don't do that very often.
No.
So
that's the rub, according to the plaintiffs in these cases.
But what we're also thinking we're going to see is now that they've kind of left the table, that they're going to come back with more things, right?
They are. That's exactly right. I think
they've dropped the gloves now.
I think they're going to say that this offer of compensation is a violation of the Sherman Antitrust Act. It's anti-competitive.
So
and
then
what would be their resolution to that?
Yeah.
Well, they don't have to have a resolution. The DOJ doesn't have a resolution. Remember when they broke up AT&T?
Right.
They don't come in with a solution unless it's a settlement. They come in and they do it, and then the marketplace creates the solution.
Right. So what would be a reasonable solution?
That's a great question. How do realtors,
how do we adjust?
Practitioners adjust and that's the key question.
Right.
How do you adjust and remember the question we used to ask, what's currently possible, and if it were impossible, it would fundamentally change the way you do business.
Yep.
Well, what's currently possible is an offer of compensation through the MLS.
Right.
If it wasn't possible, that would fundamentally change the real estate business.
Absolutely.
Well, this would be then potentially buyers paying their own agent commission.
Maybe.
If you had one.
Maybe. So there are probably, we could brainstorm through a lot of things. So in my mind, the first thing that comes up, John Riley and I talk about this all the time. He wrote the books on agency, right?
Mm-hmm.
That first of all, the people will probably try to fix it through a contract, right? Mm-hmm. So think about in the offer to purchase, it'll say certain things, right? Or so there are ways around it being a rule in the MLS.
Right.
So I think what people have to do if they're looking for solutions is they have to look at what they want the outcome to be.
Right.
And then look at the way
backwards
it's now
from there
done and work backwards and say, this is the way we will solve this as an industry. And so that we're not guilty of any antitrust and so that people are getting paid.
Right.
So that's where that is. Now, the interesting thing, so you understand that it's like the foundation of what MLS offers, its value proposition might go away.
It might go away. So then what?
Yeah, but I was thinking the MLS though, I thought their main purpose was a marketing tool.
Well, if you look at the MLS is what they bank on is it's an offer of compensation. If you look at what I think they say, what does the MLS do for you? It secures the compensation for you, so you're not afraid to negotiate. Right, that's the big thing.
Got it. Okay.
And is it a marketing tool? Of course, right? And maybe, and I think a very important marketing tool. And
absolutely.
It does a lot of great things.
Like how a lot of other countries are around the world that have no MLSs.
I think it's a miracle. Right, it creates this marketplace that you don't have anywhere else. Mm-hmm. But then you have people say, "Well, look at in the rest of the world, they only pay 1% commission or 2% commission. So obviously, it's all screwed up in the United States because they're still paying 5 or 6."
Right.
Right. And so, well, it's different maybe to sell houses in Europe than it is to do it in the United States. And we certainly sell a lot more than any of those other countries.
Right.
And there are other issues that their industry has to be concerned with. So the big one based on these cases right now, this is when you hear that the Department of Justice has decided to back out a settlement, there's all kinds of other things, but what that means is the Department of Justice is going to do what it's done for years. It's going to look for a way to break up what it believes are antitrust aspects of the real estate business. Now, this is not new. Antitrust in real estate, I got 2 volumes, and there's the 3rd volume of cases. It's been going on for years. And in my own MLS in San Diego, we've been involved in 3 antitrust lawsuits since I've been involved.
Right.
I've been involved a long time, but since I've been involved, 3 major antitrust lawsuit cases. And there's lots of antitrust cases, that for years. So
Are they mostly like for the California one, of the 3, did California, who won or what was the outcome?
Well, so one of them and a couple in California, we had the big one was the Paulson decision. And you might have heard of that decision, which says that it's a violation of antitrust law to make somebody join the Association of Realtors to access the MLS. That's illegal tying. And because everybody needs the MLS to function. And so if you say you have to join our organization to also get the MLS, then that's antitrust, because people who don't want to join your organization, they don't get to do business.
Mm-hmm.
That's illegal tying, according to the Paulson decision, which is California. Then there was the Thompson decision, which affected 3 other states, right? Florida, Georgia, and Alabama. Same thing. And the ruling there was, in both cases, you don't have to be a realtor to join the MLS.
Okay.
Right. There's books of cases. Those are some major cases. Now, here's though what the thing that we're concerned about now. I don't sell real estate anymore, but I think people need to be concerned with is the offer of compensation is under threat.
Yeah.
Now and so what would you do if there was no guarantee that you were going to get now, actually, I think it might be kind of a good thing. It would make people do what I told them they should have done 30 years ago, which is get a contract from a buyer. Not a disclosure, but a contract. And then the contract can say, I'm going to get compensated so much. And it then could say, but I'm going to get it from the other side or however I'm going to get it. But at least we got a contract. And we've been pushing that to the back for years, haven't we?
Because we thought about this on Real Estate Fight Club. It's like, should the buyer pay their agent? And
they're already paying them. They just don't realize they're paying them from the wrapped into the price of the house.
I'm saying like pay them as part of like the buyer agent agreement, and then they negotiate it, right? So, but the argument is that how are they going to pay that? Like if it can't be wrapped into the loan or whatever.
Well, so
I have to think it's for some closing costs, you'll be able to wrap that into the loan in some way.
So there is an issue with the way that the loan stuff is structured now. Doesn't mean there has to be, if we looked at it, you can achieve the same outcome.
Right.
And so, the buyer doesn't need any cash. If they're willing to sign a contract that says you're my agent and you're going to get paid, we're going to put this deal together. We're going to ask the seller to pay the commission, because remember, compensation doesn't indicate agency.
Right.
So that could be in a buyer agent contract, not a disclosure, right? But an actual contract. I call it a listing agreement.
Right.
It's a listing agreement for a buyer. Right.
Just like on the seller side, they sign an agreement. They don't put any cash up.
Right.
Same thing could happen on the buyer side.
Right.
And we'd have to work to make sure the contracts match. And so there are solutions to this.
Yeah.
Beyond the way that it's currently done. The way it's currently done is we've got this clause in the MLS rules, and now it's being challenged. Now, that clause hasn't always been there. That clause only got there in 1992.
Wow.
There was not an offer of compensation that way.
What happened before?
Well, prior
it was all
to that,
sub-agency, right?
Yeah, prior to that. So the MLS it was a unilateral offer of sub-agency.
Mm-hmm.
Now there was a process. So when I first started selling real estate and I knew this, right? In the 70s, everybody was saying, well, you represent the seller.
Mm-hmm.
Now they didn't explain why. They said, wait, I'm talking to the buyer. No, you represent, because we're members of the MLS and the MLS structure, and it was structured this way to avoid antitrust. So there were reasons that got into play, right? And so they created this unilateral offer of sub-agency.
Mm-hmm.
And so we all knew that we represented the seller. In the 70s and 80s, when I was selling real estate, I knew I represented the seller. I knew a lot more than most people. Most agents just knew they represented this. They didn't know why. The instructors would say, make sure you never call the buyer a client. You always call the seller a client, and you call the buyer the customer, and you owe the customer, fair, good faith and honesty, but you have a fiduciary duty.
Right.
to the seller, and the buyer didn't even know that, because you didn't have to tell the buyer that. And
Because they
so
weren't your client.
so the buyer's saying, oh, here, I'll offer 100,000, but I'm willing to go to 110. And they're telling that to the agent of the seller.
Right.
Mhm.
Right. So so there are people that didn't like this, and they fought, particularly an organization called the Consumer Federation of America.
Mhm.
And a guy by the name of Steve Brobeck, he's like me, he's still around. And they've been pushing this for years. So what happened in the 70s was, in California, because of all this push that buyers are getting ripped off, buyers don't know they're not represented. There were 3 bills on the floor of the legislature in California, and one of them wanted to, and it also revolved around dual agency.
Right.
And so they wanted to outlaw dual agency. And
there would be no dual agency if everybody represents the seller.
But back in those days, there could be dual agency, right?
No.
Yeah, there could be, because, and actually it was divided agency, because the other side didn't know, right? Undisclosed dual agency.
Okay.
Right. And so by virtue of the fact that the MLS is an offer of subagency and the buyer doesn't know. So what happened was, there were these 3 bills. One wanted to make dual agency a criminal offense.
Wow.
Criminal. And so the California Association of Realtors, and I know all this, I was teaching real estate classes at the community colleges and at the big real estate schools here in San Diego, and I was practicing real estate, and this was the brand new thing. And so I was calling, actually Alex Creel was the legislative advocate at CAR. I was talking to the legislative advocate and to the advisors before this actually got passed. This agency disclosure law got passed, and it passed. It was unanimous, right? So they passed this agency disclosure law in California. It's actually a compromise, so they didn't outlaw anything. They said, look, this is how we'll fix this. We'll just tell the buyer and the seller who represents them.
Okay.
That's the solution. Let's just do that. We'll do a disclosure.
Right.
So they said, so they created the disclosure forms, and so now, and they gave us 18 months to implement and start using the disclosure forms.
Mm-hmm.
The disclosure form, you could check, you represent the buyer, you represent the seller, or you represent both as a dual agent.
Right.
And so that you had this disclosure form, but they didn't change the MLS rules. So the MLS was still a unilateral offer of subagency.
Oh.
And so that meant I represented if I took the listing, I represented the seller. If I was with the buyer, I represented the seller. That's with the MLS rules.
Yeah.
Then they passed the disclosure law, but they didn't change the MLS rules, because the disclosure law was passed by the legislature, and then we're talking MLS. So what we had is, we had agents who didn't know any better. They got this new agency disclosure form, and so they know they have to disclose. And so now they talk to a buyer. They say, well, there are 3 ways to be represented. I can represent the buyer exclusively. I can represent you. I could represent the seller. I could represent both of you. I'll represent you exclusively.
Yeah, but they
why would you not think that, right? So so the agents started checking the box. They represent the buyer exclusively. The fact is, they represented the seller.
Right.
So what they ended up with is a divided agency, where they told the buyer they represented the buyer, but they didn't. Right. So now you have a divided agency, which you can break the sale apart. You can disgorge the commission. Everybody selling real estate was documenting that they were breaking the law, right? Right. Documentation. Oh, you remember the MLS? Yes. Did you have this form signed and you check the box that said you were
the buyer? Yes.
So CAR said, well, we can't allow our agents and brokers to be in jeopardy like this, because California passed this disclosure law. We need to change the rules of the MLS. We got to change it from an offer of subagency, so that buyer agents are not representing the seller.
Yeah.
And so in California came up with this idea of an offer of compensation instead of an offer of subagency. Okay. And NAR said, no, we don't want to do that. And California said, well, our people are in jeopardy. So California, kind of renegade, passed its own MLS model rules, and they called them the California model rules. And in the California model rules, it wasn't subagency any longer. It was offer of compensation. And then NAR changed the NAR model rules, and that was good from 92 until a couple of years ago, right? So the offer of compensation that's now being challenged was a remedy to the subagency.
Right.
So this is not new. This is all a continuation of what's been happening for many, many years.
This is very interesting. So that original paradigm shift question about, so it's like, what is possible now is the offer of compensation through the MLS to an agent that exclusively represents the buyer. And what if that were no longer possible?
Yes, exactly. Now, when people don't want to tell you, well, they'll want to get into an argument about why that should be possible.
Yeah.
Yeah, right. Done deal.
Right.
When the DOJ says this, what we want to figure out, and let's figure it out before it happens, is
Right,
if
right.
it weren't there, how would we be compensated?
Yeah.
Let's figure it out ahead of time. And that's the whole purpose of asking those paradigm shift questions.
Right.
Is you figure, because as a matter of fact, it's kind of hard to think of things, right? When we talked about this, you say,
Yeah,
well, give me an example, right?
Yeah.
Prime example.
Yeah, the DOJ gave us 4 examples in there.
Right? They said, there you go. This is possible. And if it's not possible,
What's gonna happen?
and we're going to make it not possible.
Right.
Right. So now it's up to
Crazy.
people say, well, if it's not, what do we do?
I mean,
And
there's
like I said, I think it's solvable, at least contractually. We just never looked at it very hard.
I think though too, like with any of these problems, it is solvable, but it's hard to think about what are the ramifications of the solution. I think
Right. Inevitably, when you start something new like this, or you take a situation like this and come up with a whole new way of handling it, there's going to be things that are going to come up that are going to be like, we didn't think about that, or this really could have been done better. But ultimately, I mean, we've got to figure out a way to make this happen, make this work before the MLS's offer of compensation is no more.
Exactly. Now, could the MLSs have come up with a better way to handle this over the last 25 years? Probably.
Right.
But there was no impetus to do that because nobody thought it was nobody thought anything was wrong with
a problem.
Right? Because you think attorneys looked at all this before it became part of the MLS rule? Yeah, I'm sure.
Yeah, I'm sure they
before
did.
we made these, right? So it's not like
Right.
there was no legal, and no, people thought about it, and it's being challenged now.
Yeah, it's just if you don't have a problem, why create problems?
Right.
But
if it ain't broke, don't fix it.
Yeah. And the bottom line is that people have been fighting for buyer agency rights for years and years. I don't know if you saw. I went back to Boston in 1992 to meet with Ralph Nader. Do people still know who Ralph Nader is?
Oh yeah.
Right. So to meet with Ralph Nader, because I was an advocate for buyer representation.
Yeah.
Right. Because I thought it was important for agents to get contracts because they so often didn't get paid for what they did.
Right.
And if they had contracts, they would get paid for what they did. So I pushed back in the 90s this whole idea. And because I could see that the buyer, now what happens is that buyer then becomes a seller. So it all kind of balances out.
Right.
But still, you should get paid for the work that you do. And you should get paid fairly for the work that you do.
Right. So, well, and then there's the key word is fairly. If you leave this up to the buyer to determine what's fair compensation for their agent, you're going to get a whole lot of buyers that are going to say, well, you've been doing this for free for the last 30 years, you should just keep doing it for free, therefore I'll pay you peanuts.
But this is an interesting question for me to you guys, and that is, when I sold real estate, I don't think I ever said to anybody that what I do is free to you.
No.
I don't think I ever said it. Do people actually say that to buyers today?
I still see advertisements and marketing pieces and social media posts and all kinds of things that say, I free. I'm like, stop saying it's free. It's not free. And why do you want people to think we work for free? There's two concerns with that.
Painting the wrong picture, right?
Right. You are not painting the right picture for the rest of us.
I don't know. This is a lot to unpack. I feel like we're going to need to do another video as updates come.
Well,
absolutely.
I think you're right. And I think that where people need to focus today, if they have time, and you've got the information, put it up on your blog, right?
In a vault. I put it in a folder. So it's in jennifermertland.com/vault.
So important to look at the current civil suits, and they're antitrust. They are class action. That's a big deal.
Yeah.
right? Class action lawsuits, and they're particularly big if the DOJ is behind them.
Yes.
Right.
And the DOJ, their rules, and the FTC enforces. These are like the dual arms of the federal government. When you got these entities coming after you, right? So NAR has been able to hold them off, but here's what happens then is that it's going to be costly. It's going to be time consuming. It's going to make NAR take its, and a lot of other people are going to take their eye off the ball.
Right.
And there's many other things that we've talked about.
To focus on the other things. So what's going to happen at the other hand?
Yeah. So this big piece we've been talking about, the changing in zoning and higher density and more housing and more low-income housing and federal funding, all these things that we know are going to happen. Maybe the DOJ didn't want to have its hands tied because it's going to want to achieve a number of other things in the field of real estate. And if its hands are not tied, it can probably get some capitulation from the people that represent realtors.
Right.
Agreed.
And I think that's part of the plan as well.
Oh, for sure it is. Yeah.
So, because remember, there are a lot of big things the government wants to achieve.
A lot.
Right?
Yeah.
It wants to achieve more walkability. It wants to achieve climate. It wants less driving. Right? Want people to drive less. There's all these things the government's going to try to achieve. It's got a lot of funding that's going to come after it. There might be some organizational obstacles.
Right.
And what the government would like is allies in pushing its agenda forward.
Right.
And you can get allies a couple of ways. Okay? Carrot and stick. And so I think this is wrapped up also in a bigger picture. And whether or not it's organized doesn't matter. I think you have to treat it that way, right? Oh, that's the conspiracy theory. Those people aren't talking to one another. Doesn't matter whether they're talking to one another. What matters is the result.
Right.
Right. And if the result looks like there's a conspiracy, you have to treat it as if. And so I believe major change is coming to the real estate industry. Major change.
It's been like bubbling for a long time, but it seems like there's a lot that's getting pushed through that wasn't being pushed through before.
So I always tell people about change. Change always takes place. It bubbles along. It just, there's not enough of it so that when you walk outside,
to blow the lid off, right?
So why don't you walk outside, you see it, and you say, "Wow, that happened overnight." No, they've been working on this for years.
Right.
And so it manifests in something tangible for people. And what we're going to see is the manifestation, more tangible results from a lot of these government efforts to curb the real estate industry, for whatever, right or wrong, right?
Right. It's just what it is.
It's just what it is.
It's a lot.
So as a realtor, you need to, as a real estate person, we should be looking for opportunities, because a lot of people will want to get involved in the dissent.
Yeah.
And they'll waste all their time in the dissent and not enough time looking for the opportunities created.
Right. No, that's true. Is your website and stuff up yet, Saul?
The data, I got a call this afternoon. So they go look today, the data advocate. We're actually going to start. There's a lot of it. When John Riley and I reviewed the case in 2008, for people who are interested in this, that 2008 case is interesting.
Yeah.
Agency disclosure and how that moved the needle. That's an interesting piece. And I think all of this is going to get surfaced because it's all relevant
to now.
Yeah.
To the offer of compensation.
Right. So we're going to put it up everywhere. We'll give it to you. You can put it up,
Perfect. And then if people want to get a hold of you, because we're scratching the surface here, right? But
absolutely.
If people want to get a hold of you and maybe they didn't understand something or they have a question, what's the best way, Saul?
Saul at bettercallsaul.realtor. So it's .realtor. It's a new top level domain, about 5 years old. Saul at bettercallsaul.realtor.
Awesome. And then Rachel, if people have a referral in Chicago, what's the best way to get a hold of you?
Best way to reach me is my cell phone at 630-542-8688.
Awesome. Well, thanks, Saul.
Hey, one more thing before we go. Does this just leave you with this thought? Because this is what I've been studying this, and for the last couple of months, every time I think I have a solution, I realize I have to step it up one more level.
Yeah.
And then I get to where I think I understand it and I have to step it up one more level. And so I think I've got it to pretty close to the top now. And this is what I think is happening.
Okay.
The land use policies in the United States are now obsolete.
Okay.
We've outgrown our land use policies in this country.
Okay.
And so now there's the money and the policies to change land use policy in the United States. And if you change land use, you change property values.
Yes.
Right? Because what are the 4 elements of value? Demand, utility, scarcity, and transferability. Right? So you change the use, utility of the property, you're going to change the values. So now there's a reason for this. What we've done for years, we have plenty of land, so we just build more, build more, build more, build more. But if you walk around your own neighborhood, what you might notice, at least I do in mine, that the state government or the city government, they don't even take care of the neighbors. They don't cut the weeds down anymore. They don't water the plants anymore. There are potholes in all the roads. The infrastructure's falling apart. People who work downtown got to drive 3 hours to get to work to earn minimum wage, and they got to drive 3 hours to get back out. And it doesn't work anymore. The police, we don't have enough money to send the police out to this sprawl. And so to make things work, we have to change our land use policies. And that's the underlying factor here, is that land use policies in this country are now going to change, because what you need to make it change, money and policy, it's there. We know that it's there. The government, the strong arm of the government is there, and the real estate industry is a giant industry.
It is.
So think about land use, think about a major change in the way we use land. That's a paradigm shift. Now we're talking about not just change, but fundamental change. And the tip of the iceberg is taking away that compensation piece.
Yeah.
It fits into a bigger picture.
Yeah.
Absolutely.
It does. Oh, it's a lot.
That's what makes it fun.
It's a good thing we have somebody to break it down for us.
I know, right? Awesome. Thanks again, Saul. We'll see you next
Thanks, Saul.
time. Better Call Saul.
Great seeing you guys.
Bye.
You too.